Everybody got lots of rest and relaxation. I see Ken didn't, but thank you. We're back. It's Tuesday afternoon, March 11th, and we're looking at H 342. But before we get into it, just a kind of explanation of a little bit of an explanation of what we're doing with this bill. So the bill is actually primarily within the jurisdiction of the Commerce Committee, as far as data brokers and the privacy issues that are involved there. What we're looking at is a couple things. We're looking at primarily what is the need for this bill, what kind of threats are prosecutors, defense counsel, judges, et cetera, facing. We'll hear just kind of very briefly kind of what this does to try to address that issue, but what really getting into what it does to address the issue is really commerce. So we're really being asked kind of more narrowly. We could have really even done a drive-by, but it ends up that this was sent to us first. So we have jurisdiction over the bill. There's a couple other things that we can comment on that are really within our jurisdiction, and that's as far as some of the court outcomes as far as damages, punitive damages, reasonable attorney's fees, and there's a negligence standard that will be addressed as well. And those are things that we can weigh in on. So I just wanted to, so it's relatively narrow. The idea is that we'll look at this, and at the end of all the testimony, we'll decide if we want to have a straw poll to say, yes, this is a problem, and Commerce, please fix it. I'm hoping that tomorrow afternoon and on the floor, I will ask to be relieved of the bill and have it committed to Commerce for them to do their work later this week. So with that, we'll start with the walkthrough. Let's say council. Thank you for being here.
Yeah, good afternoon. So Rick Zegel, Office of Legislative Counsel, and I believe this is my first time in House Judiciary. Yeah, so I know some of you more than others. A few I have not met before. So again, Rick Zegel. My portfolio is mostly Commerce Committee. That's why I'm here. This is, as the chair said, this is a mostly commerce bill. Information technology, business, commerce. You may have heard of data privacy. That little bill falls under my portfolio. AI, those kind of things are my purview. So I won't be in here often, but occasionally I will be in your committee. So 342, and Mr. Chair, should I share my screen? Would that be?
Yeah,
okay.
That'd be great.
It starts out with findings, which I will let you all read on your own because it's plain English. If you don't know much about the reason for the bill, there's some history behind it. So it might be, and I'm sure your witnesses will testify to the reason for the bill and the intent behind it. So for my purposes, I'm going to start on page 2, the bottom of page 2. So we're in Title IX, probably not one you guys are in often. Title IX of Commerce and Trade. It's one I'm in all the time. Hold on. Yes, make sure I have about 20 documents open. I want to make sure I'm in the right document. So we're starting off with Chapter 62, Section 2448, the definitions. And I'm going to highlight some of these. I'm not going to read you word for word what's in here, but a couple of them I want to point out and make sure you'll understand what the definition means. So assignee is pretty straightforward. It's a person that has been assigned some kind of right by a covered person, and I'll talk about what a covered person is in a second. An authorized agent is an important definition because in this bill, you'll see that a covered person can authorize somebody to act on their behalf to eventually remove information or request that information be removed about them, their personal information. And you can see here, it could be a subdivision A, it could be a designated trustee or other agent pursuant to a written power of attorney, could be a parent or legal guardian on behalf of a child who's a minor and who's otherwise entitled to protection in this law. C, a person or entity that has been appointed pursuant to a notarized document by a covered person to act for the covered person or the submission or revocation of requests for redaction or non-disclosure. So this could allow a company, a business that you as the person want to hire or appoint to act on your behalf as well. Okay. Also important is covered person, which people are actually protected by this bill. You have active former judges, law enforcement, prosecutors, public defenders, parole and probation officers, municipal employees, and employees of the Family Services Division of DCO, and the immediate family members of that previous subdivision. And that's later on defined, but I do want to hide this real quick. Yeah. Which one is it?
Previously 12.
First one I had. Yeah. Okay, so immediate family, and again, this is cited later in the bill. It's an individual spouse, domestic partner, civil union partner, child or foster child, sibling, parent, or such relations by marriage or by civil union, or an individual claimed as a dependent for federal income tax purposes. Okay, let's go back here. So data brokers are the entities that are going to be, I don't use the covered, but they're the ones that have to be applied to law, that this law applies to them, data brokers. And you probably don't know much about data brokers. I do have the definition of data broker pulled up. So this is in, by the way, this is in 9 VSA 2430. So a data broker is a business that knowingly collects and sells or licenses to third parties the brokered personal information of a consumer with whom the business does not have a direct relationship. And you can kind of see here, there's some examples of what a direct relationship looks like. It could be a customer, a client, subscriber, an employee, contractor, investor, donor. Data brokers tend to be companies you've never heard of. With a few exceptions, but they tend to be companies that, you don't go shop at a data broker's store. The store may contract with a data broker, but data brokers tend to be, I don't use the word nebulous, but they're not name brand companies that you would recognize.
Quick question on data brokers. Are these regulated entities for the most part?
In Vermont, we do have a registry. They must register with the Secretary of State's office. So you can go to the office or go to the website and do a search for data brokers to see if they are registered. But it's pretty limited on what that, oversight is.
Right.
That's
Is
kind
there
of
federal guidance?
no.
Okay.
Okay. Any questions about data brokers? What they are?
I have a follow-up question, sorry. Well, this is actually just going back just quickly on covered persons.
Mhm.
Where is that definition derived from?
You mean where the word for word
Yeah.
comes from? I would talk to the sponsor about that exactly.
Just because we've had conversations in this committee about what covered persons is or isn't, and I'm just curious to make sure that we have uniformity across statutes that.
And so with this, because covered person can mean different things, like in the healthcare
That's what I
context.
mean.
Yeah. So you almost don't want uniformity. And that's why we define, here's what we mean. When we say covered person, we mean this. So in a lot of ways, you kind of have to have that lack of uniformity to ensure that we are covering, the right people.
So I guess let me caveat that by saying, insofar as it relates to law enforcement as a covered persons, that's where I'm curious where the definitions come.
Let me continue with the definition thing.
Yeah,
You may have your
keep
question
going,
answered.
but I just want to make sure that's noted.
Sure. Disclosing, you can read that. That's a pretty straightforward, what that means. Home address is a partial or complete street address or some other information that reveals a home's location. Home telephone number includes landline and cellular telephone number. It's whatever used for primarily personal communications. Showed you the definition of immediate family. Judge means any justice, judge, magistrate of the Vermont Supreme Court, Superior Court, or Vermont Judicial Bureau, and any judge or magistrate of a federal court in Vermont, or any person who serves as a judge, justice, or magistrate in another state who maintains a home address in Vermont. Okay, so this may help you. Law enforcement officer, we use this cross-reference. Let me hide this again. I came back. 20, Title 20 section 2351A. So this is the definition that we are cross-referencing. I'll let y'all maybe read that on your own time. What includes that? Go back to the bill. Along the same lines, a municipal employee has a cross-reference of 21 VSA 1722. There it is, it's subdivision 12. And again, I'll let you read those on your own time. If you have questions about it, just let me know. A parole and probation officer means a corrections services specialist employed by the Department of Corrections, or a parole or probation officer employed by a Vermont county or municipality. 13, prosecutor means a Vermont state's attorney or deputy state's attorney or a U.S. attorney or an assistant U.S. attorney. There's a request from the AG's office that we add the attorney general and assistant attorney general, which I tend to agree with. That was an oversight, that they should also be covered by prosecutor. Okay, protected information. This one is fairly important here. So this is information that the law will protect: your home address, including your primary residence and any secondary residence, your home telephone number, personal email, your social security number or driver's license number, and a license plate number or other unique identifiers of a vehicle owned, leased, or regularly used by a covered person. Okay, finally, public defender means defender general, deputy defender general, public defenders, or deputy public defenders that work pursuant to 13 VSA 163. That's your chapter devoted to public defenders. Any questions about the definitions? Okay. So here is what the crux of the bill is: that a covered person or an agent that you hire or retain has the right to send a notice to a data broker that they are publishing information that is protected: home address, number, email, those kind of things. 2, upon a data broker, which, remember, that's a specific group of entities in Vermont, upon receiving a physical or electronic notice from a covered person or a agent requesting that they cease disclosing or redisclosing the protected information, the data broker shall cease disclosing the information not later than 10 days after receipt of the notice, and shall not disclose or redisclose the information after that time. There's one discrepancy I'm going to get to. We have 10 days here and 10 business days later on, and I'll talk about if we want to correct that or not. So this notice shall be in a form provided by the Secretary of State, except that the notice shall not require prior verification of a covered person status or agent status for that notice. So again, that's important. Someone could just claim that they are so-and-so and send notice. I don't know why they would do that, but you know. The Secretary of State shall publish this form not later than 90 days after July 1st of this year. However, until that notice is posted, covered persons or their agents may use their own form of written notice that references this section, identifies the sender as a covered person or as an agent acting on their behalf. A broker that receives this information pursuant to that subdivision that does not cease to disclose or redisclose the information more than 10 business days. This is the discrepancy I'm talking about here. I think you might want to have the same number of days. Either it's 10 days on both sections, or it's 10 business days in both sections. So, and that might be something for the Commerce Committee to take up. But so if more than 10 business days go by, they shall be subject to the following penalties in a civil action brought in Superior Court by the covered person or the covered person's assignee. So you're giving the agent the ability to file the suit on behalf of the person. Damages, which are either the greater of actual damages or liquidated damages, which equal 1,000 per violation. So liquidated damages are not super common in Vermont. We do have them, but if you've never heard of liquidated or you maybe don't know what it means, it's kind of like minimum, right? So you can read this as, if the actual damages were $100, the liquidated damages would be 1,000, and that would obviously supersede the actual damages. You see them a lot when it's fairly like a complex contract. Like if you have some kind of agreement with two businesses have some kind of agreement, and sometimes it's tough to determine how much harm has happened through a breach of contract. So it'll say liquidated damages shall be, $25,000, and that makes it easier in some ways to you don't have to go and litigate the amount of harm that's happened. So here, the idea is that the harm is fairly certain, that someone's protected information is worth $1,000. And that's the way it's written.
So I have a question, and I'm just thinking about this in terms of, say there's like a collective infraction of multiple, and so say there's a data set that includes all the data of the 150 members of the House of Representatives here in Montpelier. If that is, so this 10-day timetable elapses, there would be $1,000 infraction for every single one of our member data that's been disclosed for each preceding day.
Well, not for you all, because you're not covered, right?
But I'm saying
right.
hypothetically,
Right.
like you say, you have a data set of 150 individuals that are a covered person.
Right.
It would apply to every member that's part of that data set.
Correct.
We don't have concerns that this could be ripe for abuse.
Not a question I can answer.
Okay.
Any questions about?
But there's no limit. Also, a follow-up question. There's no limitation. So say there's a data set that includes, there's not going to be 100,000 covered persons. I wouldn't think in the state of Vermont, but say there's a data set that's out there that is encompassing of all covered persons, enumerating up to say 100,000 people. Like there's no ceiling of what the infractions could be.
That's right.
Okay. I'm going to have more questions, but this is helpful.
Sure.
But just going back to what starts this all is that a covered person actually has to send a notice or,
Well, what if
seek to.
But if it's done via class action, or if there's like a union that is representing.
So you would still have to have that initial notice, right? And if they take it down within that 10 business day timeframe, then there's no lawsuit, right?
Right.
A class action would have to be totally separate after the 10 business days has gone by, and that's kind of a whole separate issue, is creating the class action.
So, and I agree. So, but I think, as far as the scenario that I'm playing out in my head is, say the Attorney General's information is leaked and, she becomes a covered person under the statute, that's one person. If you have, say, 40, 50, tens of thousands of individuals that are exposed in a data breach, or is being exposed in this, that is a huge amount of people that 10 days, it wouldn't be possible to pull that data back, I wouldn't think.
Probably a question for a data broker representative to answer, like how difficult that would be. I don't know.
Yeah, I'll tell you, like, for background, my background's in technology data, namely financial data. And I can tell you that we have some of the most sophisticated people on the planet that are doing this for us. And I can tell you doing something like this would be impossible. So I just think the 10-day, I don't know where that was inspired from. I don't know where the language came from. I know that there's other legislation out in the ether that this maybe has been inspired or based off of. But the 10-day infraction period, it just seems untenable to me. But again, like this is, again, not directed towards you, but I think just broad scopes about concerns about this bill.
Sure. I should mention that a lot of this is from New Jersey's specific law.
Yeah.
They have, yeah, right. So New Jersey has a version of this. I believe it's the only state that is, because that's where the incident happened.
Yeah. The judge's son.
Right.
Yeah.
So again, I guess I just want to make sure I also understand that I understand your concern, but is it still a concern if the covered person, how would, is there a situation where there could be 150 covered people that all of a sudden, I mean, could somebody like be an agent for all of the union people
Yes.
and can then send in and say, hey, I'm sending this in for these 200 people? And
Yeah.
you can figure that out.
So one of the lawsuits in
Okay.
New Jersey on this law has, one of the agents is representing several plaintiffs. And
Okay.
I don't know how many it is, but it's more than a handful. And they've all been hired by this company, or they've hired this company to, remove their information. They've handled the outreach to remove the person's information. They didn't do it within 10 days. So then there's eventually a lawsuit filed.
Okay.
Yeah.
All right. So yeah, I see how that would work then, Zach. Thanks for bringing that up.
Okay, subdivisions, B, punitive damages. So this is more common than liquidated, at least calling for it. As you all probably know, judiciary, it's up to the court a lot of times to determine if this harm amounts to a punitive, which is like a punishment, right? You punish this person because the harm was so bad. You can always write it in statute. It's a choice. And here it currently is in the bill. And the standard is upon willful or reckless disregard of the law, which again is kind of the point of punitive. It was so bad. The harm was so bad that we should punish the defendant, right, for doing this thing. That's what the point of punitive is. So again, it's a choice whether to include that or not, but it's a court can always add it if they would like. C, common reasonable attorney's fees, especially in consumer protection, which this is kind of a consumer protection, even though the consumers are very limited, these protected people. However, it's common to call for reasonable attorney's fees and other costs reasonably incurred. And then D, any other preliminary and equitable relief as the court determines to be appropriate. Okay, subdivision 5. This calls for or sets forth the standard of default, which is ordinary negligence. And this is actually, I think, a response to what happened in New Jersey, which did not include that standard.
Right.
The court kind of grappled with, is this a strict liability issue? What's going on here? So here, the bill makes it clear that this is a ordinary negligence, except of course punitive damages, which requires this willful or reckless disregard. That'd be a higher standard than just the other actual damages.
Can you explain the negligence standard for us?
Oh, it's like in torts class, what a reasonable person would or would not do. So in this case, in this context, if you're a reasonable data broker and you receive notice from a covered person that you think is a legitimate request, would a reasonable data broker delete that information? And you would say yes, right? As long as everything seems in order.
So does this possibly get at Zach's concern, which I agree with them as far as the 10 business days, if you have a whole bunch of people? I mean, the negligence standard would be reasonableness. Is it reasonable if you have 200 individuals, covered individuals that you have to do clear from their database or whatever? Would it be reasonable to be able to do it in 10 business days? So I'm just wondering, as a possibility of changing the 10 business days to a reasonable, tie that into the reasonableness standard. I mean, that it should be a reasonable, information for, I don't know how you word it, but rather than a specific number, have a reasonableness standard since it ties to number 5 there, subdivision 5.
Yeah, it's an interesting idea. I would be slightly concerned that what's reasonable to one judge or jury may not be reasonable to another. So you said 200.
Well, but that's what negligence
Right.
standard is to begin with. I mean, you've got the
Right.
negligence standard in there.
Right. So yeah, it depends also how you word it, right? If you word it just using the phrase within a reasonable time frame, that would allow the data broker, if they receive 1,000 deletions on one day, a reasonable time frame might be, again, I'm just going to throw it 3 months. I don't know, right?
There would be arguments over whether
Right.
negligence or not.
Right. I think in some ways it would be harder for a covered person to know if harm has happened. Like if they contact a data broker, if they hire an agent to handle that, and the agent sends the notice and their information is still there 3 months later, how would the covered person know if this is reasonable or not? Right? They're lay people. They don't know how big is the data broker. Is this data broker a conglomerate? Do they have a million different consumers profiles on their databases, or is it a small data broker, which I don't know how small they get, but so I agree in some ways, but then I also think that it wouldn't hurt to have some kind of bottom baseline number, or I don't know what that would be though. That's up to the committee to discuss.
Or it could be 10 days per covered person, or there's another option. I mean, so, but definitely that's a concern. I don't know if it's for us to ultimately resolve that as opposed to say, hey, this is our concern. And here's some suggestions for the folks down the hall. But I can also talk to Marcotte and see if he wants us to.
And I'm only just reacting to what's.
No, absolutely. No, I appreciate that. No, I appreciate you. So.
Yeah, I guess I would say for me, it's not a concern yet. I want to hear more about their ability to
be able to
all
do
that.
200, 300. Well, that's where
yeah, and if that's
where it's their issue.
committee.
That's why I'm flagging this as a concern, but that's not necessarily for us to necessarily resolve, because that may take digging deep into data
Mhm.
brokers, and that's what they do.
Yeah,
So,
no, I'm not looking to go down that rabbit.
yeah. So, all right, back to.
Okay, just one more page here, page 8. Let me actually, hold on, there's the second sentence in subdivision 5. So the bottom of page 7, it shall not be a defense to liability in a judicial proceeding that the covered person's protected information is or was available to the public from other sources on the internet or otherwise, or available by inspection of poker. That's a pretty big carve out there, because it's likely, well, not likely, it's possible that this information that a data broker has, which is protected, is actually also with a governmental agency or some other, website that may not be a data broker and would not be subject to this law. So this is a carve out saying that just because this information is elsewhere does not mean you too have to still take it off.
Go ahead, Jack.
Would an example of that be like a credit bureau?
Any internet source. So could be. Yeah. Okay, 6. If you or an agent access the data broker's website to determine, hey, do they have my information? That does not mean that you've agreed to any website terms. This is kind of, I guess, there are times where a company might trick a covered person by you agree to the terms, you click a checkbox saying that you agree, you waive your right to have your information hidden. So subdivision 6 addresses that, saying that you cannot avoid being liability by just having the person agree to terms on a website. Subdivision 7, a disclosure of protected information shall not constitute a violation if the disclosure is made with the express authorization of the covered person, provided that the authorization is provided subsequent to the relevant non-disclosure request, or is for the sole purpose of facilitating a transaction initiated by the covered person. So, effective date July 1st, 2025.
Wait, any other questions just on the language? Ian?
Yeah, just can you remind us where our jurisdiction is, the damages section and reasoning for this?
It was to understand if we have any red flags or problems with, that damages and the reasonable courtesy through the damages, equitable relief, and then that negligence standard, which I think will at a minimum, we will raise that concern about the negligence standard and how that relates to 10 business days, and getting 10 business days is the appropriate thing for them. They need to dig into that. But our primary, that's secondary, actually. Our primary is just to hear from people we frequently hear from, judges, defenders, prosecutors, law enforcement, to understand the problem, how big of a problem is this? And then we will ship it over if we all think that this is worthy. Well, we'll probably ship it over one way or another, and we'll say, we don't think it's a problem, but we'll leave it hanging on their wall.
Yeah.
Or we think it is, depending on the testimony we get. So,
In that case, can I ask
Yeah,
a
go ahead.
question on language? So I think on the damages then, so as I'm trying to understand the issue, what would be punitive? Like, I guess, like willful, reckless disregard. So they get this notice, which is to remove it right now within 10 days. They don't.
Right. Good question.
And then my second question is just, so like talking civil law here and courts, what are the damages if the information is already online?
As far as like already on a different non-data broker website. So that would play, I think, a role, and it'd be up to the judge or jury to determine, like, this information, yes, you were supposed to take this down, you didn't do it. However, this information is also easily found on this other website, which is, not subject to the law. So again, that would appear to affect damages, but I'm not on the jury. I would not be the judge, and that would be up for them to determine, should we maybe deflect some, because
But under the, on page 7, the 5th subsection here, they couldn't, there's no like affirmative defense to, they couldn't sort of preclude any action based on.
correct. So you
It'd be
could,
more of an analysis on the damages.
correct, right. It's not, yeah, they would still be, liable, but the amount of liability would maybe go down based on the availability of the information on other websites.
Yeah.
And to answer your question about the punitive damages, I can give you the classic example, which I'm sure Chair Lalonde knows about. Was it the Ford Pinto? Was that what it was?
Well, it wasn't my Ford Pinto.
Ford, the Pinto had a design flaw to where I think the gas tank was kind of in the back of the car. And whenever there's a rear end collision, the car would frequently burst into flames. So Ford knew about this. And they had a decision to make. Either they issue a recall and fix all the Ford Pintos and fix the exploding gas tank, or they just assume that we're going to get sued a few times for a few deaths and it'll be over. They chose option B. And it came out that they made this decision, that they thought about this, and they said, oh, we're going to choose money over lives. So the judge in that case issued punitive damages.
Sure.
So that's kind of an extreme example, right? But it's meant to be that you knew this was bad and yet you still did it. Therefore, we must issue you additional damages because this is punishment.
Yeah.
Yeah.
Okay.
Yeah.
That's helpful.
Yeah, go ahead.
I have a question that I think is sort of outside of our jurisdiction, but since we might be able to raise some flags.
Yeah, no, absolutely.
I was just curious on page 6, line 12. The data broker shall cease disclosing the protected information. Is there a reason that the cease disclosing was chosen over deletion?
Not that I can recall. I'm not trying to be cagey. I don't know. There might be a reason. Instead of deletion, is that what you're asking?
Yeah. Why not ask the data?
Because we're not asking for them to delete it from their databases, right? From their internal databases. We're asking to stop publicly publishing the information. So that might be why. And if you go back up to the word, what disclose means, that might be helpful too. On page 4. So it doesn't just mean publish. I say publish, but it means a lot of things. It means sell, manufacture, give, provide, lend.
Right, but they can still hold on to it.
Yes, or include within a searchable list or database, regardless of whether any person actually searched. Yeah, so obviously, if you have it internally, no one's ever going to know that you have this person's protected information. But once it's searchable and available, then that becomes a disclosure.
Right. I'm just wondering if to be, yeah, if they're holding on to the information, they might accidentally disclose it again. I just think it doesn't necessarily go as far as we could to protect people.
Going off Representative Arsenault's question, and I hadn't really thought of this until she raised this, is when you think about disclosure, and like I do think the definition here is very interesting because all of a sudden, what if, like I think of in my past life, we had access to almost every American's mortgage data, and homeowner data, and obviously all of the financial data that goes along with that. If that exists in a private database, I mean, it doesn't say anything about publicly searchable. This is just an internal database that we have with data that's been purchased legally. That would, I mean, that would attend, like this would impact that example as well, right? If like I think of Fannie Mae, Freddie Mac.
Mhm.
I think of Rocket Mortgage. I think of Redfin. I think of all. I mean, the list goes on and on. That this isn't just covered. I mean, covered people are going to appear in almost every single one of those databases, and they're massive. I mean, we're talking, if you have access to every American's mortgage data, you're talking 300 million Americans.
So you still have to be a data broker. That's one thing. But
What's
right.
the definition? The definition of data broker isn't really defined.
It is no, it's a cross reference to 9 DSA 20. I should have this memorized. 2430, and it's a very here we go. It's so I have it here. We go 4A. So I read it. You can look at it again.
Yeah,
but it's a pretty specific type of business that does not have a direct relationship with a person.
But I think, I mean, like, and I mean this again, this is not directed towards you, but I think with all due respect, like data has become such a widespread currency in the age that we live, and data begets data, very much like momentum. And so the companies that are in the data business are trying to consume as much as possible, as quickly as possible. And they're doing that even more so with artificial intelligence and like when you start implementing large language models on top of that. I mean, this is a very complex world that we're trying to navigate. And this definition is just, it doesn't really seem adequate to capture the scope of what we're talking about here, in my mind, because this would apply to almost every business on Wall Street. You could make a case. I mean, any consumer-facing technology company or fintech company that interacts with any kind of data set that is out in the public sphere, this would apply to.
I can't answer that, but I hear you.
So I anticipate that Commerce will have testimony. I mean, I've had people reach out to me who want to testify here, both like data broker, for instance, and one sitting right behind you, and I've shipped him to the Commerce Committee to go over just these kind of questions. So definitely that's something they need to probably look at. But we can't resolve it here.
No, just raising the
Yeah,
flag.
no, that's, and I want to go back to raising one other flag.
Sure.
And this is maybe more in our bailiwick, but maybe not. And that is on page 7. And it's something that Ian kind of started on talking in 2021, that it shall not be a defense to liability. And it kind of seems like it should be a defense. And what you're saying, that it's just possibly going to affect damages, but I don't know how it affects damages if we're talking about liquidated damages, because that's just $1,000, right, for each instance. So I'm kind of flagging that as really is there a good rationale for that? I mean, and I'm probably where we're not supposed to be either, but I mean, if they can get it anywhere on Google or and if they can show it's available, why should they be subject to damages? Yeah.
Especially if you can get reasonable attorney's fees too.
Yeah, especially if you can.
So if you can't assert it as like a defense and you get pulled through a whole lawsuit and then you have to pay their attorney's fees at the end of it. And it's like, and all their information is available the whole time on a different website. I guess
Yeah, disagree.
No, I totally hear the concern. I think it's just, how did that information get to all those other places on the internet?
Right.
Perhaps through a data broker,
Right.
I mean,
But my
I think
point is
this
only
is-
that it's out there already.
right. So I totally get it. And I think this is trying to help data brokers become more responsible.
Yeah, I mean,
In part.
I could imagine a situation where if they get a request, they quickly send it out and put it on Google. Because then they have made themselves a defense. So that
Right.
it's not so clear whether it should or should not be a defense. Maybe we'll kick the conversation.
Good point. I not thought about that.
Vote.
Yeah, Ian.
on talking about the definitions for the different peoples, the page 4, defining judges, we're including judges who aren't judges or magistrates in Vermont, but who live in Vermont and are judges other places. Is that sort of similar to for 13, why it's just U.S. attorney or assistant U.S. attorney and it's not like specific to the District of Vermont?
You're asking, okay, and you're going down to
To
13.
Prosecutor line 12. Yeah.
I mean, I think. How else would you word the U.S. attorney, like saying that someone that's working as U.S. attorney in a different state but lives in Vermont? Is that what
I was just wondering why it wasn't explicit to Vermont for the U.S. attorneys, because there are a lot of them.
That is a good point.
So,
Yeah.
U.S. attorney of District of Vermont, or but maybe I don't really know enough about that to know.
And you know what? I thank you because a couple days ago I read that and I just forgot to note it. But you're right that is potentially not loophole, but so Mr. Chair, on line 13, prosecutor, not line 13, subsection 13. I think
A couple changes there.
yeah, I think it'd be smart to limit this U.S. attorney or assistant U.S. attorney who lives in Vermont, might be, or works or lives in Vermont. And however, I need to work on that wording, but I think it's to match the judicial definition. Because this would include all U.S. attorneys around the country.
And theoretically, if that were the language to stay, I'm just curious. I don't
Right.
know this or not. Could a U.S. attorney like in California bring an action in Vermont because the broker is doing business in Vermont, and so you could, yes. Interesting.
Any other questions on the language?
I would just say I don't know all of the definitions of all of these other things like law enforcement, municipal employee, parole, probation, and parole officer. But I guess where all of these sites are, I would just make sure that they are specific to Vermont.
Right.
Say the first part again.
So I'm not going through all of these sites that you're making
Yeah, the
definitions.
Yeah, I had them all pulled up at one point.
Okay, so all of them are very specific to people being in Vermont.
Well,
Do you see my?
I do. Let me.
So I would just want to make sure that all the definitions for all these different people are somehow connected to Vermont, so you don't get the situation that I'm talking about with the states.
Right.
And then I guess the other thing would be for immediate family. So does that mean that somebody who's living outside of Vermont, who is an immediate relative of someone who's living in Vermont, could bring an action in Vermont for a?
Yes.
Okay.
Yes. Yes, that one I'm sure about. The law enforcement I'm looking at.
Yeah.
I think law enforcement's going to be limited to Vermont. The municipal employee is going to be limited to Vermont.
They probably all are.
The defender general, yeah, but the immediate family would not be. That would be, it could be your brother, sister in Texas or whatever. Could be.
Yeah.
All righty. All right. Thank you very much.
Sure.
It's good to have you.
I have to run, but I'll be I'm sure I'll talk to you about next steps.
Okay, all right, appreciate it. So we're gonna go to Matt Valerio. We're gonna jump ahead of Matt Atkinson and go to Matt next. Thank you for being here, Matt. Good to see you again.
Thanks for having me. For your record, I'm Matt Valerio, the Defender General. Reviewed the bill, of course, and surveyed public defenders regarding the concepts in the bill. Nobody had any idea what this was about. They
Hey,
didn't understand why there was a need for it. They didn't really see a problem. They haven't experienced a problem. And the level of ambivalence was strong. Actually, it was unanimous. Really, there was nobody, we have no idea why we're even included, or nobody even knew what they were trying to protect, I guess. So apparently something happened somewhere and some state passed a law and now we looked at it and so we're going to try.
A child was killed.
Okay.
Yeah.
Well, that happens everywhere. And sorry for that. But nobody here really understood it. Didn't know where it came from. So the point really is nobody's against it. Nobody's for it. Nobody has an opinion whatsoever on the bill. Nobody really feels that the people I talked to about the damages portion, to the extent that they may be impacted in some theoretical way, they don't feel like the damages really would deter anything or do anything. I ran it by the appellate division and obviously looked at it as a lawyer myself. There were some, without doing any honestly deep research on it whatsoever, there were concerns about Commerce Clause violations and First Amendment violations. If you acquire data legally in a business context, what can you do with it? I will say from a past life, having had a couple of businesses that deal in all data, not just data involving these kind of people, those would be kind of concerns that I would have had if I had a different hat on. But with my hat as Defender General, there's really no position whatsoever to take. If, public defenders don't usually like to be singled out for any purpose. Don't feel like the ones I've talked to, now I haven't talked to everybody. I didn't send out a big survey or anything like that. The two questions I got is, why is this being proposed? And I only learned today that apparently there was an incident that gave rise to this being proposed. But I couldn't answer the question. And then the second thing was, and I already said it, assuming that there was some issue that would be covered by the bill, what does $1,000 do anyway? I understand the potential for punitive damages if there was a willful breach, and I could talk about standards for when that might be applied and that sort of thing, but I don't think that's why you asked me in here. So we really don't have any position on it. I could have probably said just that, but I did want you to let you know that I didn't just come in and say I looked at it and I didn't think there was any big deal. I did actually survey everybody and they really just didn't understand it.
so would you prefer if this were to move that public defenders gets taken out of it, or does it matter one way or
I
another?
don't think anybody cares either way. I mean, if we were out of it, it'd be fine too. I mean, the bottom line is like the harassment and the the public defenders get, it's not like this. It's like every single day. It's by clients and other folks who are unhappy with what's going on. It's not this sort of thing where the issue is. And in Vermont, if you want to find out where somebody lives, you don't have to go to a data broker. I mean, drive to Proctor or Rutland and say, hey, where's Matt Valerio live? when they're over there. I mean, that, if you want to harass somebody, that's how you do it. So nobody hides in Vermont very easily. It's really the point of that. So the bottom line is the constituency I'm dealing with really didn't see a need for it. In general, public defenders don't like to be singled out as having any extra protection or extra anything. In other bills that you've had, regarding maybe assaults or the like, we've always asked to be left out of it, because they usually don't really stop it. It's just something else. And
I think Ian had a question. Did you?
I was just gonna ask you, do you get complaints about public defenders who are targeted like outside of court, have any kind of like issues with clients or clients' families that's like could be worse if they could find that person's information online in a way?
honestly, I don't get complaints like that.
Okay.
The complaints we get are just the one, somebody shows up at the office complaining, or they write a threatening letter, or they leave a threatening message, or, they threaten you to your face, like that kind of thing. It's not this at all.
Yeah.
I'm mindful that any kind of incident can happen anywhere at any time. But I'm not sure that if that kind of thing happened, even with a bill like this, that doesn't remedy that situation either. So, but like I said, we have no position. We're as ambivalent as I've ever had any people that I've talked to about a bill that said their name in it ever happened. So that's really it.
Okay, so I appreciate it.
All right. Great.
Thanks, Mike. Thank you very much. All right, well, I'm going to go to Matt Adkison. Did I pronounce that right?
Yes, sir, close enough. Thank you.
Identify yourself for the record and.
For the record, I am Matt Adkison, CEO of the Atlas Data Privacy Organization. Very happy to be here with you all. Thank you. I've made a few notes that I'm going to use to structure my remarks, and then happy to take questions and just kind of speak from the heart about what we've been doing. So as I mentioned, I'm the CEO of the Atlas Data Privacy Organization. We are now over 50 people who for the past few years have worked on privacy laws. And for the past 2 years, we've worked on Daniel's Law in New Jersey. We went to New Jersey at the request of the law enforcement community there following a tragedy that occurred that I'll talk briefly about to help them implement this law. So we're here because of Daniel's Law in New Jersey. In July of 2020, there was a federal judge living in New Jersey who was targeted for assassination by a disgruntled litigant who had practiced in her courtroom, who lived on the West Coast. And that disgruntled litigant made a hit list of individuals who he had grievance with, looked up their information using the type of data broker resources we've talked about today, and killed his first target in LA, and then drove out to North Brunswick, New Jersey, where he, posing as a FedEx delivery man, intended to assassinate the judge. Her 20-year-old son was home from university. His university had shut down because of COVID. He ran up to answer the door and was shot and killed, preventing the gunman from getting in the house. And then his father, the judge's husband, was shot and almost died responding to that. And then the judge was home at the time also. 4 months later, New Jersey passed Daniel's Law, named after Daniel, who was killed. It was the strongest privacy bill in the United States, but very narrowly targeted. It was focused on protecting judges, prosecutors, and law enforcement officers. And it focused on just two pieces of information: home addresses and home telephone numbers. So that's why we're here. New Jersey worked for a few years to get the law right through several iterations. I met with representatives of the law enforcement community in New Jersey. They asked my team and I, who had a background in national security and cybersecurity, to come out and help build out tools and services that would allow individuals, covered persons, to assert their rights. And that's what I've spent the last 2 years of my life doing. We've learned a lot along the way. We signed up about 20,000 covered persons in the state of New Jersey. We launched our service with them. So these individuals were able to send out the type of non-disclosure requests that you see in the bill here. That was in December of 2023, 14 months ago. When those initial notices went out, we saw a range of compliance responses. Some data brokers complied. This is great. We understand the purpose of the law. They had no problem complying. That includes individuals running solo proprietor data brokers, managing hundreds of millions of rows of data, but literally by themselves out of their living room. And we had big multi-billion-dollar companies similarly understand the purpose of the law and want to comply. And then we had a very different experience on the other end of the spectrum. We had very large companies say in writing to us, we will never comply with this law. Never. It will never happen. Based on those responses that we saw, we went and recruited a legal team that could help these individuals assert their rights and could help us assert their rights as the assignee of their claims. We are often smeared now as ambulance chasing plaintiffs' lawyers. I am not a lawyer. I should say that probably up front at the beginning of every testimony I make. I had never sued or participated in litigation of any kind prior to my starting the organization that became Atlas. In fact, I was usually on the other side of the fence, running large companies, many of which I started, dealing with hundreds of millions or billions of rows of data. I came to appreciate a couple things working in New Jersey over the last couple of years. The threat environment that these public servants work under is terrifying. It doesn't matter if you're a federal judge or a new correctional officer guarding inmates at a jail or a state trooper patrolling the highways and the roadways of a state. You are constantly operating under this shadow of fear that because of some interaction you have in your public duties, blowback from that could target you or could target your family in a violent way. Not everybody talks about it. These tend to be very stoic professionals, but the fear and the concern and the anxiety is endemic. And we respond to many incidents of harassment, doxing, threats. I sit with a lot of these people literally around the kitchen table. They open up to us, and that's what you realize is that the fear is endemic. And it's not unjustified. It's the gift of fear. As Gavin DeBecker says, that fear keeps you alive, but you wish it didn't have to be there at all. So that's one. Two, the lesson we really learned was, and this is part of what made Daniel's Law so powerful, is it included a private right of action, which I'm sure you'll hear a lot of talk about. The individual, if their rights were ignored, had the ability to go to court and seek relief, something almost no other privacy bill in the United States included. If I can leave you with just a few takeaways, one of them would be, without enforcement, the bill means nothing. Any privacy law in the United States, if there's no effective enforcement, it's not even worth the paper it's printed on. We came onto the scene with Daniel's Law following 10 years of privacy bills having been passed and then not enforced. Our organization, for the first time in US history, really tried to enforce a privacy bill. And we were looked at like we were a three-headed alien that had just arrived from Mars. I was told we were, offered to be paid off, and no, if you just want money, here you go. And then we were told explicitly, privacy laws are not meant to be enforced. They're meant to be for show. This is supposed to be sort of a Potemkin village Soviet theater. What are you doing? You are upsetting the status quo. And if this law dealt with abstract issues, I think there could be maybe more of a debate about it. But Daniel's Law dealt with life or death issues, and we were dealing with these people every day who had concerns. In many cases, as you can read in some of the material we've put out, they had very violent threats made against them, armed individuals arrested outside their houses and things like that. So the need was enormous, and therefore our commitment to enforce the law was commensurate with the need that we saw. There's a lot of discussion about the PRA. I heard some of the discussion here earlier. I'll note a few things in the bill here in Vermont. An individual, before they can seek relief, sends that notice to the data broker. And then there's the 10 business day compliance period. The data broker can cease disclosure of the information. There is a authorized agency provision in the bill, but it requires the individual to sign and execute a notarized data proxy or power of attorney or document with whoever the representative would be. So it would not be possible under this bill to simply click a button on a website, sign up hundreds or thousands of people, and then, off you go. It is a very high, and I think an appropriately high bar for that authorized agency. In our work, we found some people who said, look, can I meet that threshold? Can I sign a notarized power of attorney, and have some other agent do more effective work on my behalf? While we were running Atlas, there was a judge in Maryland who was killed by the name of Andrew Wilkinson. He was a family court judge. He had a hearing in the morning. He ruled on a temporary custody issue against a litigant. That litigant looked up his address online, drove to his house, waited for him to come home, shot and killed him when he pulled into his driveway. This is a problem, has been a problem for a long time. The threat environment is getting worse, particularly in the last 90 days. I think you'll hear from other witnesses about this. The threat environment against judges in particular has become the worst anyone has ever seen. It is becoming normalized in our political discourse to threaten a judge online. And as I know one other witness will testify to, the problem is when threats become normalized, there are elements, individuals who are either very malicious or not stable, who will act on those threats and will hear those threats as a dog whistle to actually participate in violence. And maybe the last thing I'll say is, and then I'm happy to take any questions, is data brokers range a broad spectrum. As I said, we deal with a lot of great data brokers. Data is not inherently good or bad. It is a tool that people use for different purposes. I deal with a lot of great data brokers, again, individuals, and they're working out of their homes up to huge companies who want to do the right thing and help protect people. And then we deal with a lot of data brokers who are very malicious. Just in our cases, and this is all public and can be viewed on the docket, we are chasing data brokers who are run by organized crime overseas in Russia, in Cyprus, in China, people who, very malicious companies who are ideologically committed to the destruction of any privacy law and have either they've been in industry groups where information has leaked that reflects this, or they've told it to us directly. There are very good actors and very bad actors in this space. This is the analog for our cases is very much big tobacco or opioids. Within the community of data brokers, there are companies like Purdue and like big tobacco. They will lie, they will obfuscate, they will threaten, they will bribe. Nothing is out of bounds for them. So, we've got the best lawyers in the country. We're dealing with that in court. You will absolutely see it here in Vermont as well. And then maybe like the last thing I'll say is that prosecuting these cases can be very expensive. For an individual to hire a lawyer and go to court is tens of thousands of dollars in retainer. Maybe eventually there's the hope to recoup fees. That doesn't prevent the need for some retainer to be paid in those cases. Our organization only exists because there are some very senior, very wealthy lawyers who care a lot about privacy. And my partners and I have a background, and we're fortunate to do well enough to then give back in this way. We have spent tens of millions of dollars collectively prosecuting these cases over the last year, and we're only probably about 20% of the way through. And despite that money, despite being in federal court, first time I went to federal court, there were 90 lawyers in the courtroom, 5 on our side, 85 on the other side. One of our lawyers told me, it's the first time I'd ever been in federal court. They said, this is a $2 million day. The defense just spent $2 million. And so these are not cheap enforcement actions. And unless there is financial incentives in the law will simply not be complied with. So I'll leave it there and happy to take any questions.
I have a question. So and thank you for being here. So following the passage of Daniels Law in New Jersey, Governor Murphy instituted the Office of Information Privacy. I think that's right. And what we saw in terms of a trend in New Jersey is the privatization of enforcement of Daniels Law. And I'm curious if you think that we would see something similar if the bill was enacted here in Vermont.
Well, fundamentally, what the bill allows an individual to do is if their rights are ignored, they can go to court and seek relief. There is a lot of precedent in US law and history supporting that. There's a law called the TCPA. If Domino's Pizza or any other commercial organization sends you an unsolicited text message, you can sue and you are owed under the statute $500, $1,500 if it's negligent, if there's some malicious standard, but you're owed $500. And to the point that I heard earlier, if Domino's Pizza, not to single them out, but let's use them as a hypothetical example, if they send 1 million Americans unsolicited text messages under the statute, they're liable for $500 million. Now, there are a lot of constitutional protections that kick in where the circuit courts will say it can be $500 for an individual. There must be limits put on when claims are aggregated together. So there's a lot of protections that exist for companies that are not explicitly referenced in the bill. But when you talk about private enforcement, that is the only enforcement that has been effective in the history of privacy law and in the history of many other analogs in US law. Environmental cleanup, tobacco, the big tobacco settlements only succeeded because there was private enforcement. Opioids, same
I
thing.
guess, sorry, the contrast that I'm trying to get to, I guess, is you have this really horrific tragedy that happens in New Jersey. And the comparison and contrasting that's being done with big tobacco, big pharma, it just seems like these are very different. Like, help me bridge the gap. Like, I'm just trying to understand like where these are likened to, because I mean, you look at the Sackler family. I mean, like people are giving them death threats on a daily basis. So I'm just trying to figure out like where, like, bridge the gap between those two worlds.
The widespread disclosure of a judge's home address or a prosecutor's home address or a law enforcement officer's home address subjects that family, that individual and that family to the risk of threats, harassment, and death. We have many cases which we've talked about publicly that are public record because we filed them. There's an incredibly courageous couple in New Jersey, husband and wife who were both police officers. She was featured on a YouTube video, did nothing wrong, but her, along with 6 or 7 male officers, the internet mob focused on her because she was an attractive female, targeted her and her husband with the most vicious and vile death threats possible. It escalated, and the police ended up arresting 2 armed men outside of her home. I think she has a 3 and a 5-year-old now. I think they were 2 and 4 when the gunmen were arrested. This type of stuff happens all the time. It's not talked about. I celebrate the fact that the public defenders of Vermont seem to be immune from threats. I can tell you that's not the experience we've heard in any other state where we have chatted with public defenders. So my congratulations to them. But that is the level of threat we're dealing with. And if you go out and talk to people, your neighborhood cops, prosecutors, people who work in these positions, you will hear stories. They will open up to you. Big tobacco killed people and hurt people. Opioids, pharma, same thing. These data cartels that are publishing and disclosing this information for profit are doing the same thing. Money over lives is a great way of describing what many of these companies are choosing to do.
Have you received testimony specific to Vermont where you hear of instances like this happening?
Absolutely.
Can you provide some examples of that?
I've chatted with some of the other witnesses you'll hear from today, and they will provide those incidents. No one is immune from these types of threats.
Right. And last question, are you guys a nonprofit? Are you registered? Like 501c3, 4?
We have a 501c3 organization, and we have a traditional corporation.
And the traditional corporation, who is backing it? Because I read that it was Lightspeed, Y Combinator. Are they still investors?
So the vast majority of our funding comes from David Boyce,
Okay.
a lawyer who's the founder of Boyce
Yeah.
Schiller Flexner,
Yeah. Yeah.
who's in a kind of, he's a famous
The voice of
lawyer.
Clinton, right?
No, he was a former Cravath partner. He started his own firm, Boyce Schiller Flexner.
Okay.
He teamed up with Ted Olson on the marriage equality constitutional stuff. And John Morgan, a lawyer in Florida. These are 2 multi-billionaire iconoclastic lawyers who care a lot
He was the
about.
Theranos lawyer, right? He was in the.
I don't know all the cases they
Yeah.
represented, but I'm sure if you Google it,
Yeah.
you have his case history.
Yeah.
And my partners and I who have put in capital as well.
Right.
And we've aggregated together people who care a lot about privacy. We have been attacked because, again, people accuse us of trying to profit in court as abusive plaintiffs participants. We've pledged publicly, I'm happy to do it here again today, that all of the profit from these lawsuits, if there is any, because right now we're negative many tens of millions, will be allocated to the C3 and a C4 that we intend to set up. Without that funding, honestly, these protections will not be sustainable, even if they are enacted. So happy to provide more clarity on that if it's helpful.
Thank you. I yield back.
Yeah, go ahead. Randy.
Thanks for being here. In your experience, are the companies that are willing to, the data brokers that are willing to comply, are they typically able to do so within 10 days, 10 business days?
They are, and we know that because we have many examples of data brokers who complied with tens of thousands of requests within 10 business days. Again, these are businesses that on a daily basis deal with tens of millions or hundreds of millions of rows of data. This is their business. They ingest it, they manipulate it, they curate it, they send it out via API or disclose it to other partners. The compliance in our view is not difficult. And again, the evidence of that is that many companies, hundreds of companies we believe complied, and dozens we talked to and actually know they complied fully with the law.
One other question. No, I lost it. It'll come back to me. Go ahead.
Yeah.
10 days question I had. So you said you're 20% through the lawsuits that are in New Jersey on Daniel's Law. Are they being appealed, and are any of them potentially going to go far enough up to challenge that it could impact us in Vermont if we were to try to implement this?
That's a great question. So 20% is my layperson's estimate. Again, litigation and being in court is a totally new experience for me. I simply came to appreciate that without enforcement, the bills mean nothing. So the first thing, we're in a mix of federal and state court cases. And again, not being a lawyer, I may butcher some of the semantics here. The first thing some of the defendants, the large data brokers, did in federal court was mount what's called a facial constitutional challenge to the law. They said the law is very noble, but it is not constitutional. It runs afoul of the First Amendment. And there was a lot of argument. That was that first day I was in court, walked into a room and saw 90 lawyers and thought, wow, what is this? That was the start of that facial constitutional challenge. We got a ruling after 6 months of briefing and argument the day before last Thanksgiving from the federal trial court judge that Daniel's Law is constitutional. And I'm summarizing, but he found that the state of New Jersey, as the state of Vermont would as well, has a compelling state interest in protecting these public servants, and that the risk of harm is great. And that, again, if the rule of law is threatened, democracy kind of falls apart pretty quickly after that, if you look at the historical record. And so defending judges, prosecutors, law enforcement officers, public servants who enforce and administer that rule of law is a compelling state interest. It is constitutional. It does coexist with the First Amendment. That decision is now being appealed to the Third Circuit. But I think I had not mentioned in my testimony, the Congress of the United States passed an analog to Daniel's Law called the Daniel Anderl Judicial Security Protection Act. And the Supreme Court has talked about this. It covers all federal judges and the Supreme Court justices. It provides for a $4,000 prior right of action, I believe. And so it's been on the books for a while. So we survey the landscape. In every case where a court has ruled, they have ruled that Daniel's Law is constitutional. We do not have concerns about the constitutionality of the law at this point.
And are you working on any other states right now to try to implement similar laws?
We are.
Which states?
Based on our work in New Jersey, we really have become the center of gravity for these public servants who are threatened. So we get outreach from dozens of states. So we're active in the majority of states, I'll say, trying to help their judges, law enforcement officers, prosecutors understand and deal with these threats. And Vermont, you have some very genuine legislators here who care a lot about privacy. And that's why we're here. We sort of came at their request and to offer testimony and support this bill. But we are bounded only by our resources. We would love to see Daniel's Law become a law in every state and help protect the people who need it. So, thank you.
Okay. So
you said home phone numbers, right?
Yes, sir.
Do people still have home phones?
I tried to get one 6 months ago, a landline, and they wouldn't sell me one. I live in an area with pretty spotty cell reception, so they actually wouldn't sell me a copper line. As defined in the statute, home phone has become a label for exactly what you're alluding to, which is it's a cell phone. Most people think of their home phone as their personal cell phone number these days. So I think the actual language in the statute is unpublished home telephone number, which is defined as a landline or a cell phone that's used for personal purposes. And again, we see, classically, we'll see this on an almost weekly basis where an officer will be involved in an incident and their phone will light up with death threats and nasty, nasty stuff. Imagine waking up, I'm pulling from real, examples just in the last couple of months we've dealt with. Imagine waking up every morning to text messages on your phone that say you should kill yourself. You should probably consider hanging yourself, or, we're going to see you later. Like, I have a friend who not too long ago was involved in an incident. That's what he wakes up to every morning. It's a tough guy. Former Marine, became a school teacher, became a cop because he thought he could do more good as an officer than as a teacher in a classroom. Mentally, even if people are very physically tough and very resilient, that type of harassment breaks people down. And they shouldn't be subjected to that because they're out doing a tough job as a public servant on behalf of everybody else. And it drives good people out of public service. I mean, some of the most heartbreaking stories I hear are predominantly women who are in law enforcement or prosecutors who feel enormous guilt because they're out doing these jobs, subjecting their families to threat. And they feel like they're being a bad parent because their kids are at risk because of the job they've chosen. And a number of them, after they're involved in these incidents, say, I'm out of here as soon as I can get out of here. Some wait until they hit their first pension vesting date. Others just leave early. All that threat traffic does is deprive the state and the community of the very people who you want in those jobs, who you want as officers and prosecutors and judges. So I hope that answers your question.
Well,
I know there was more that literally answered the home telephone and then added on to it, but yeah, so a cell phone would be considered a home phone.
I mean, I think any of us that are in public service have probably been threatened. I know I've been threatened with having crosshairs right on my brain.
Except public.
If there is a brain up there, but I'm not sure. I'm not sure how this has gone about does what you're looking for, because everybody's already protected. It's whether the law goes and enforces like a stalking or something like that, correct? A stalk, if you're being stalked, that's against the law, right? If you trespass on somebody's property, that there's already laws in place in this. So I'm trying to understand how your group, for lack of a better word, goes above and beyond and does anything more for protection.
Well, let me give you a concrete example. So Judge Wilkinson, the judge in Maryland who was killed, a few hours after he was killed, we found out about what happened. I Googled his name, Andrew Wilkinson, Hagerstown, Maryland.
Yep.
His address, his home address where he was shot and killed, was the first result. So imagine you're that angry litigant. Maybe you're a malicious, violent person by nature. Maybe you're just having a period of mental instability. You're angry at this public servant. You leave the courtroom, you Google his name, and there's his home address. That's not unlike putting a loaded gun in somebody's hand and saying, here's the information you need to go vent whatever grievance you think you have. Daniel's Law is meant to stop that, along with other things, but that's an example. An effective Daniel's Law in that state would have removed the judge's home address from those avenues where that litigant might have found it.
So, may I continue?
Yes, yeah, a lot of this is for Commerce to figure out, but go ahead.
So all this stuff, it's like my home address is already all online. My tax bill or tax information from the town is all online. I mean, I'm nobody special in my mind. I'm certainly not a judge, but we're still public servants in this building that a lot of people don't like what we're doing. Um, I, I'm trying to wrap my head around of how you're protecting anybody from this happening. And I'm not getting there. I'm looking for some sort of guidance from you or something with that. It's like I see a lot more. Let me put it this way. I see a lot more lawyer work being done for laws that are already in place. How's that?
Well, there's no law in place, to my knowledge, that would prevent, again, using Judge Wilkinson's example, that would prevent the disclosure of that home address. So if you have a family court judge in Vermont who makes a tough custody ruling, and a litigant Googles that judge's name and their home address is the first result, that is an avenue for threat. And I'm not aware of any law that Vermont has that would prevent that. That's what Daniel's law is. And that's what we're trying to do. I mean, look, fundamentally, and I respect honest people. We have data brokers who, to our face, just say we don't think these people should be protected. Okay, fair enough. But fundamentally, it's up to the legislature in Vermont, you all, to decide, do these public servants deserve this level of protection or not? If the answer is yes, great. If the answer is no, someone can take that position and say, I think that if you're going to be a judge or a prosecutor or an officer, your address is out there. The testimony I can provide is that puts families under enormous threat and ultimately discourages good people from doing very tough jobs. The federal judiciary has gotten more vocal about this. It's very difficult to convince people to be judges now. It used to be that the pay gap was the biggest challenge. Now it's fear of putting their family at risk. But the best concrete example I can give you to answer your exact question is, you think about somebody angry, a litigant leaving a courtroom or even out of state, someone, a judge in Vermont has to make a ruling about something that comes out of DC, and somebody angry from another state looks up the judge and says, can I find their home? I'm going to go pay them a visit. That's what Daniel's law is meant to prevent. Criticize them all you want, publish whatever you want, but make it much more difficult for that angry person to find and harass and target and threaten that public servant and their family.
So Karen, Tom, and then Zach.
And I realize our role in this was trying to just determine if we should proceed with this, if it's needed by these potential what's the word for it? Not service providers, but group of individuals.
Covered persons.
Covered persons. Thank you. So I want to try to focus on that piece of it. And one thing that is that this was initiated by legislators. So it wasn't that there were the groups of attorneys or judges coming to seek out this legislation.
I think Daniel's law in New Jersey really came about because of the advocacy of Judge Solis. So based on what I've read, her son was murdered. She channeled her energy into trying to protect other families, making sure something like that was less likely to happen again. To her enormous credit, that's what she did. And 4 months later, she was able to really be the force that directed the passage of this law. So I would say it really did come from the judiciary. Similarly, the federal analog has been talked about extensively by federal judges and by the Supreme Court. You can read Chief Justice Roberts' annual letters to the court. He had a very explicit reference in this most recent one saying a judicial system, to the extent I'm paraphrasing, to the extent a judicial system cannot and should not live in fear. Judges and other administrators of rule of law and justice shouldn't live in fear. Those jobs have to be jobs you can take and you can rule and you can do your job impartially. If you're a judge, you can do that job impartially. You can issue rulings impartially. If you're an officer, you can arrest or not arrest, detain, not detain. You can do the job without having to worry at every step of the way, if I do the right thing, is my family going to become a target?
Sorry, I should have clarified. So hearing that the New Jersey one was initiated by, but in Vermont, it sounds like being initiated by legislators, not necessarily the covered persons that initiated it.
So we, as I mentioned, we've really just become the center of gravity for this threat traffic. I certainly talked to folks from Vermont and many other states who raise these threats as a concern. After that, we got to know some of your legislators who are, to their credit, privacy, very passionate about privacy and privacy advocates. And they invited us to come here. So again, Vermont, I spent a lot of time in this state. I went to school in Massachusetts. One of my best friends was from Vermont, so I'm happy to be back. I spent, many, many great winters and summers here. But it's a small state, as you know. I think if our goal or someone's goal was to simply increase the total number of covered persons in the country, Vermont would be second last on the list, probably right ahead of Montana or Wyoming.
If I have one more question, because it just gets to, I'm trying to understand, I forget the name of the group or entity that you are with. And I know that you also said that enforcement is really a key piece of this.
Mhm.
And so is that something that should be a part of this bill, is making sure there's an entity like yours in New Jersey in here? Because I don't think we have that here yet. So I'm just seeing, like, is there a big piece of this missing? And it seems like if we were to do it, we have to get to that decision first, that is a key piece of it, but that's not part of this bill.
What we've seen surveying the last decade of privacy law in the United States and working with Daniel's Law for the last couple of years is that private enforcement, such as the form that this bill takes, is the only effective enforcement for this systemic type of issue. The AG offices have an important role to play. I think there's some discussion with the AG about expanding their responsibilities under this bill. Criminal enforcement is a great place for them to participate, but if AGs, attorneys general, are not resourced typically to take on hundreds of cases of noncompliance, they're not set up to represent individuals. They represent the state of Vermont. So the structure of this bill is one where an individual under threat makes the request. They have to take that action. They have to actually make a request of a data broker and say, please cease disclosure of my information. And then if they are ignored, they as an individual go to court and they seek relief. And again, there's private rights of action like this all around us. If the Ford Pinto is a great example, money over lives. If your Pinto blows up, is that really the AG's responsibility? Should there be a state agency of exploding cars? Like, the courts exist for individuals to seek relief when their rights have been violated. That is the public mechanism, publicly funded mechanism for the redress of grievances or the redress of injustice and the violation of rights as we see here.
Tom. Oliver.
Hi there. Can you hear me okay?
Yes.
All right. Thank you for being here. I just got a couple of questions. My first one is, it's two-part, I guess. In the state of Vermont and federally, do you know the number of instances on an annual or decade basis in which someone sourced information to intentionally commit a homicide in this manner with this information? Do you have any of that information?
I think you'll hear from another witness, a former U.S. Marshal, now retired U.S. Marshal, who set up the National Threat Center and was one of the first advocates and drivers of aggregated collection of this type of data. One of the problems on the national level is that states don't do a good job of collecting and aggregating and reporting this type of threat traffic together. So I know he's working on that, and there are different states that are trying to join together. What I can tell you is what has been published in the press over the last year, and especially the last 90 days from sources like the Secret Service and the U.S. Marshals, who have statutory responsibility for the protection of public servants in some cases. And the threat traffic is growing at an alarming rate. If you track the number of threats against federal judges, which is a coordinated federal statistic, I think it has grown by something like 600% in the last 5 years or 10 years. It has become a topic of conversation all around the country because of that. So there are different statistics like that I think you'll hear from other witnesses that will testify today.
Okay, I hope so. Thank you. I'll conclude there.
Zach, then Angela, and then we have to move on.
So one question, just in terms of, I guess when I think of careers, right, and I think of a plumber or a realtor, and they have day-to-day obligations and their work site changes on a daily basis. When I think of judges, when I think of law enforcement, when I think of a lot of the protected people that we talk about in this legislation, I don't really have to Google their home address to figure out where they're going to be. If it's a judge in Rutland County, where I'm represented from, the judge is going to be at the Rutland County Court. The officers are going to be in the barracks, especially in small municipalities like here in Vermont. Like it's not, and I think that's where maybe the scope and scale differs from the applicability of Daniels Law in New Jersey, is that Vermont is a much more, and you spend time here, it's a very local state. And like people know who's in their community, they know where their neighbors are, they know, again, like, Mr. Valerio said earlier, it's like we know where people live. So I guess how does Daniels Law account for the fact that we know where judges are going to be? We know where police officers are going to be. We don't really need to go to their homes to find them if someone's looking to inflict harm. There's security.
Yeah, there's a few points I'd make.
But my point there is, right, if a judge is leaving after a long day, there's not officers escorting him or her to their car at night. I'm just saying, if a bad actor is looking to do harm, it's a very simple equation to figure out where they need to be to do it.
So if your genuinely held belief is that everyone already knows where all these public servants live and it's just imputed accessible knowledge, then I guess, sure, why pass any privacy protection bill whatsoever? There's nothing in that aligns with our experience that we've had helping protect folks. The gunman who murdered Judge Salas's son drove across the country to do it. He wasn't local. You could make the argument that New Jersey is a state of 500 plus small towns. In any one of those small towns, you can say, well, yeah, pretty much everybody in the town knows where everybody else lives. That might be true in some cases. But the gunman came from outside of North Brunswick, indeed outside of New Jersey. So you're protecting against external threats. Targeting someone at work is very different than targeting someone at home. At the courthouse, there should be sheriffs there. There's security there. Many of these attackers are fundamentally cowards. They're not going to go where they might meet resistance. The home is the weak, and you'll hear this testimony, I'm sure, from others. There are hard targets and there are soft targets, as the Secret Service or the U.S. Marshals Service would classify them. The home is a soft target. The courthouse is a hard target. And then lastly, what I hear predominantly from covered persons is, if something happens to me because of the choice I made to take a tough job, I can deal with that. But what happens if my family is injured or hurt because of me being at a job? So, in your scenario, what if a judge is in trial at the courthouse and their family is at home and their family is targeted when they're not even there to help protect them? That's the concern we hear from a lot of folks.
But this bill doesn't even cover the families of the individuals. It covers the individual themselves.
It covers their families.
Okay. And so, and another question I have is, when you look at, different cases that have been brought against large data brokers, I'm talking Google, Microsoft, Amazon, these companies have the resources, and I think there's a term, called Cypre, and it basically allows Google to augment the data that they have with data that is fungible from other data sources. If they just want to pay the fine, I think they were fining California $63 million. For Google, that's a rounding error on, what they make in a minute, something like that. So I guess, how do you account for actors that don't really care about the laws here? And if it's so much as paying a fine of $63 million or $1 billion or $10 billion, they're just going to pay the fine and keep operating and disclosing the data if they so choose.
We certainly deal with data brokers who, I think, in our cases, who have that predisposition where they say money over lives. I'd rather sell, to use Rick's example, I'd rather sell more cars and simply pay off the families who die and the victims who die, because I think on a net calculated basis, I'll make more money. And we see people like that. And again, those are the folks who will be most active lobbying against this bill are those data brokers. So keep that in mind when you hear testimony on the other side. I think it's appropriate to have a criminal provision that the AG can enforce, where you can target those serially bad actors, and we certainly deal with them, as I say. Daniels Law in New Jersey includes a criminal provision. There have been criminal prosecutions where civil penalties were not sufficient to deter behavior. And that is an effective remedy. So that I would
personally.
Who do you hold accountable for that? Are we trying to bring Sundar Pichai into Vermont and, you know, have him testify in this? Like, I just, like feasibility, like, how does that actually work? Like, who are you prosecuting at Google if they're the ones infringing on this?
So I am not a lawyer, but I would hope as an American citizen, I'm not a citizen of Vermont, but I would hope as a citizen of my own state, if I were giving testimony there, that if there were a company, an American company outside of the state, putting my citizens, my neighbors at risk, flagrantly in violation of the law, that there would be some mechanism that the Attorney General or the state would have in order to hold that company accountable. I believe there is. If there isn't, that's bad news for all of us. And again, you uniquely here have the power to legislate and to perhaps remedy that. But again, I believe at that point, the rule of law being what it is, the Attorney General of Vermont would have the authority to bring that bad actor to heel. I don't know who exactly you'd arrest at Google, but you know.
But that's what I mean. It's like, it's kind of finger to the wind. It's like, where do we even start with that?
So good questions. I don't believe personally that, you know, sovereign states are very powerful entities, as I'm sure you know. You have enormous power in your legislative abilities. I do not believe that the state is powerless in the face of a large big tech company to enforce its laws. And yeah.
All right. So, I mean, just under the bill that we have here, what could certainly happen, and the question for you actually is on those, any of the lawsuits, are they seeking equitable relief, like an order requiring the company to purge their records or to not disclose the records?
They are seeking equitable relief, I believe, and it's in the form of commitment to comply with the law.
In order to comply with the law. And if they don't do that, they can be held criminally, it's criminal contempt. I mean, they can be held in contempt if they don't comply with the order. And you could definitely identify the officer in any company that would be liable for that criminal contempt. Angela.
I just wanted to possibly clear up a question about enforcement. So so Atlas data privacy is not specific to New Jersey.
No.
And so a person in Vermont who wanted to enforce, if we pass this law and and someone was seeking redress, they could potentially contact Atlas data privacy or any private attorney in Vermont.
Correct. Or they themselves could bring an action pro se, I imagine. Again, I'm not a lawyer, but yes, there are a number of different ways they could seek to enforce their rights.
I just wanted to double check that and clear that. Yes.
Tom has last question.
So I apologize if any of this has been said, and I had some constituent work to do. So you'd mentioned the AG's office would be bringing the charges forward potentially?
I think there's been some discussion of a criminal provision being added that the AG would enforce. I don't think criminal provisions can be enforced privately.
Is there any estimates on the state and size of Vermont, how many cases, criminal cases there would be for the AG's office?
I can't give that estimate. I can give an example of what happened in New Jersey. There was a very malicious individual who was threatening a covered person in New Jersey. Civil liability was not a sufficient deterrent. There was a criminal prosecution. A warrant was issued that it was a non-extradition warrant. So that individual was not extradited out of their state of residence, but it allowed for, if that individual did step foot in New Jersey, they would be arrested for the violation of Daniel's law.
And the reason I bring it up is because we've been having discussions with the AG's office and the resources they have to prosecute criminal cases. And they have, right now, they have zero extra resources to prosecute any more criminal cases than they had. And it all stems from the backlog that our state's attorneys have. And they're not even able to help them. So if we put even more on their plate, they don't have the resources to handle.
So this doesn't have a criminal provision, and if they try to do a criminal provision, it's definitely have to do here.
Okay,
Yeah,
okay.
Yeah, so right now, I think he was just saying that that's a possibility. Maybe they have
Right,
that in New
okay.
Jersey.
They have that in New Jersey and we would support that, but it's not in the bill today.
Is that something that we could put a flag in for Commerce to think about?
No, that's for us to think about if there's going to be.
Oh. Okay.
I mean, if we're gonna make something like this criminal, then it has to come through here. So, and, you know, yeah, they can decide. Commerce can decide, oh, we want to have it criminal, and if they are thinking they're gonna pass this out for crossover, and I'm not sure that that's possible, but, then if they add that, it will definitely pass.
Yeah.
Okay. Crossover. All right, so thank you very much. I really appreciate it. It took a lot longer than anticipated, and we just need like only a 5-minute stretch break, and then we won't be that far behind. Except we still have to hear from Kim as well. We have quite a few witnesses. Witness in our last time slot, sorry.
That's all right.
But I figure you're not gonna